All right, I think we're going to go ahead and start. People may be popping in, but I know everybody's time is precious. Welcome everyone to CLE this afternoon on the new regulations that the Bureau of Prisons has developed and implementing the First Step Act from that was passed a couple years ago. We're delighted to welcome Stephanie Scannell-Vasella from the BOP Counsel's Office up at Fort Devens. She's given this presentation in a number of jurisdictions, and from what I understand, she's received rave reviews. So we're looking forward to having her impart some wisdom to all of us, court and counsel and probation officers and anyone else who might be online this afternoon. If you have a question during the presentation, if you'll just pop it into the chat box, I'm going to track them, and I'm assuming we did try to leave time for questions at the end, and I'll be monitoring them and giving the questions to Stephanie once she's completed her formal presentation. Also, for those of you who are members of the Rhode Island Bar and need CLE credit, if you will email Raina Smith at the court after the CLE is over and tell her your bar number, she will provide you with a relevant certification. And she's going to put her email into the chat so you can see it if you don't already have it. And with that, I think we're ready to begin. Stephanie?
Thank you, Lauren. I appreciate it. So a couple caveats before I start. First of all, I would like to thank all of you for inviting me here today. I think it's really important to keep the lines of communication open between BOP and the bench and the U.S. Attorney's Office and the federal defenders. I worked at MCC New York for 7 years, and I think one of the benefits of my personal style was always that I really tried to keep an open door policy. So things like this are really important to that. So I thank you for inviting me to come today and give you some insight on the First Step Act as BOP is implementing it. I also want to caveat that things are constantly changing and being evaluated and reevaluated. So anything I say today, I'm giving you the most current information that I have, but it may be subject to change. BOP recently issued a revision to our program statement. I wouldn't be surprised if another one is coming down the line at some point. So I don't want anyone to get information here today and find out in a few weeks that something I said was incorrect. Like I said, I'm giving you the most accurate information as I have it right now. So with that, and again, if you have questions, please let me know at the end, and I'll be happy to answer as best I can. So with that, the First Step Act. So on December 21st, 2018, President Trump signed into law the First Step Act, which was one of the biggest prison reform statutes to date. There were 3 major components of the First Step Act. The first was sentencing reform. The second is reauthorization of the Second Chance Act. And the third was the development of the BOP's risk and needs system. And obviously we'll go into all of those in a little bit more detail. So this is outside my practice area, but I wanted to mention it, some of the sentencing reform highlights. So some of the things that the First Step Act did, it changed the penalties for some federal offenses. It changed some of the discrepancies between crack cocaine and powder cocaine with respect to sentencing. It expanded the safety valve provision, and it eliminated the stacking provision. And all of you who do criminal law, I'm sure can explain all of those things much better than I can, so I will leave that to you. But I just wanted to mention that those were some of the things that the FSA did in addition to what the BOP really is involved in. Another thing that it did was the Second Chance Act reauthorization. So it refunded some grant programs that were authorized under the Second Chance Act. And the biggest thing from BOP's perspective that it did with respect to the Second Chance Act is it modified a pilot program that we have to place certain elderly and terminally ill offenders on home confinement placement. So you may have heard about the Elderly Offender Home Confinement Program. To be eligible for that, an inmate must be 60 years or older, serving a non-life sentence. The inmate's current offense cannot be a crime of violence, and that's defined by 18 USC section 16. It also cannot be a sex offense. The inmate cannot have been determined by the BOP on the basis of criteria that we use to make custody classifications, and in our discretion to have a history of violence or of engaging in conduct constituting a sex offense. So as an example of this, I recently reviewed an inmate for elderly home confinement. The inmate had a non-violent offense, but he had a history of Code 205 incident reports. And for those of you who don't know what a 205 is, it is essentially masturbating in front of staff. And he had probably about 5 or 6 pages of incident reports for masturbating in front of staff. So on that basis, BOP said that's conduct constituting a sex offense as far as we are concerned. So we are not going to put you on home confinement under this Elderly Offender Home Confinement Program. They also cannot have a past state or federal conviction for a crime of violence or a sex offense, no history of escape, and determined by BOP to be at no substantial risk of engaging in criminal conduct or endangering any person or public. And again, that kind of catch-all, it really goes back to anything that we would use to consider an inmate having a history of violence or committing a sex offense or something like that. Another thing that we look for, an inmate must have served 2/3 of their term of imprisonment. So an inmate can't walk in the door, serve 6 months of a 10-year sentence and say, okay, I'm elderly, I want to go home. They need to have served at least a substantial portion of their sentence. The other program that was kind of reauthorized under the Second Chance Act and modified by the First Step Act is the Terminally Ill Home Confinement Program. And this is kind of designed for offenders who are, for whatever reason, ineligible for compassionate release, which we'll talk about in a second. This home confinement program is designed for inmates who need care at a nursing home or an assisted living facility. They're same as the Elderly Offender Program. Their current offense cannot be a crime of violence or a sex offense. They also cannot have been determined by the BOP and in our discretion to have a history of violence or of engaging in conduct constituting a sex offense. No past state, federal convictions for a crime of violence or a sex offense, no history of escape, and again, in our discretion, no substantial risk of engaging in criminal conduct or endangering any person or the public. The difference with this program and the Elderly Offender Home Confinement Program is the Terminally Ill Home Confinement Program. There's no amount of time that an inmate has to serve on his or her sentence to be eligible. So if they have only served 6 months of a 10-year sentence, but they, let's say, develop terminal cancer, and let's say for some reason they are denied compassionate release, they can be considered under the Terminally Ill Home Confinement Program. Now, speaking of compassionate release, I'm not going to talk a lot about this because I think through the pandemic, we all learned more than we probably ever thought we would ever want to know about compassionate release. Before the pandemic, actually before the passage of the FSA, I should say, the way that an inmate went about requesting compassionate release is that he or she would file a request with the Bureau of Prisons. The Bureau of Prisons would evaluate it. And if the director of the Bureau of Prisons felt it was appropriate, he or she would petition the inmate's sentencing court for the reduction in sentence. The First Step Act modified that and said that if the inmate initiated a request with the Bureau of Prisons and the Bureau of Prisons denied that request or failed to respond after 30 days, the inmate could go directly to the sentencing court. And I just thought the timing of that was really interesting because that was passed in December of 2018. And, 18 months later, here we were in the middle of a pandemic. And so it was just interesting timing. Let's see, like I said, I'm not going to talk a ton about compassionate release because I think we all handled many of those motions throughout the past few years. The only thing I will mention that is interesting that I heard in the news recently is that the Sentencing Commission allegedly is going to consider formal guidelines on what constitutes extraordinary and compelling circumstances. So it was a very short news article I read, and I don't know what, if anything, might come of that. And you all probably have more information than I do, especially the bench. But just kind of FYI, and keep an eye out for that, because one of the things I'm sure we all saw through the pandemic is that what was an extraordinary and compelling circumstance to one sentencing court may not have been an extraordinary and compelling circumstance to another sentencing court. And so very often I saw what I would consider to be similarly situated inmates, and one might be granted compassionate release and the other might not, simply by virtue of their sentencing court. So that's just something interesting that may be coming down the line that we can all watch out for. So other provisions that the FSA implemented. So BOP cannot use restraints on pregnant inmates. So no type of restraints, no handcuffs, no leg irons, no, nothing. We also, to the best of our ability, we need to place inmates in facilities within 500 miles of their primary residence. And BOP always made an effort to do that, but the FSA really codified that now we really have to make every effort. And the times when that can get tricky is, in particular, inmates, let's say, who need a federal medical center. So we only have a certain number of federal medical centers in the country. And if the inmate needs to be housed in a medical center, that medical center may not be within 500 miles of their home. But to the extent we can accommodate that, we do. We also cannot use solitary confinement or SHU for juveniles in federal custody. The good conduct credits, this is an interesting one because the statute, the wording of 3624B was changed slightly so that prior to the First Step Act, inmates would earn 54 days of good conduct time, but it was for each year of incarceration. The math was a little wonky, but it worked out to actually kind of only 42 days a year, the way that BOP calculated its math. Now it's a straight 54 days a year. So for example, if you have a 10-year sentence, you are eligible for 540 days of good conduct time. It's very straightforward. And when an inmate is sentenced, when we do a sentence computation, we can project out how much good conduct time he or she will receive. And each year we can break down and show, okay, this year he got 54 days, next year he got 54 days. So that's just something that the FSA codified and changed. And one thing I want to mention, and I apologize if anyone is offended by my use of the word he. I understand inmates are, any gender. It's just I deal primarily in BOP facilities that house male offenders. So my default oftentimes is to refer to an inmate as he, but just know that does not imply anything. I don't mean to offend anybody. It's just kind of the vernacular that I'm used to. So the FSA also increased funding and grant programs for job training and educational programs that BOP offers. And it also imposed a requirement that BOP assist inmates with obtaining identification before they're released. And this again was something BOP always did, but it's, sorry.
Okay.
Sorry about that.
Can I telework tomorrow and come into the office on Friday?
Okay.
Does someone have a question?
I don't have anyone to report to anymore.
I think someone needs to mute themselves. Thank you.
Sorry about that. I thought someone had a question. So yes, so the FSA also required that BOP aid prisoners with driver's licenses or state identifications or things like that upon release, which is something we did anyway, but the FSA just now officially requires us to do it. Okay, so here's probably the meat and potatoes that everyone wants to hear about, the BOP's risk and needs assessment system. So the First Step Act required DOJ to develop a system to assess an inmate's risk of recidivism and criminogenic needs. And then it required BOP to assign inmates to programs designed to address those needs, specifically to reduce their risk of recidivism. So BOP developed the pattern risk assessment and the Spark 13 needs assessment. These instruments were developed in collaboration with an independent review committee, the National Institute of Justice, the Director of the Administrative Office of the U.S. Courts, the Director of the Office of Probation and Pretrial Services, and the National Institute of Corrections. And on BOP's public website, there's a document, and I can give you all the links of all of these later if you're interested, but it specifically highlights the members of the Independent Review Committee and their backgrounds and their qualifications. And so it's just interesting if you want to know exactly who was involved in the development of these things. The IRC was comprised of 6 experts in criminology and prison systems and former senior justice sector policymakers. They also hired outside expert consultants, and they consulted with stakeholders, including crime victims, public interest organizations. And the important thing to remember right now, especially right now, is the pattern risk assessment and the Spark 13 needs assessments are constantly undergoing reliability and validity evaluations because we obviously want to make sure that they yield the same results regardless of an offender's race or anything like that. Sorry, pause. And in fact, the FSA, one of the things that the FSA, one of the things that the FSA requires us to do is to issue a report every year talking about the validity and reliability of these instruments. So the Independent Review Committee and the BOP are constantly working together to make sure that these instruments are doing what they're intended to do and doing so accurately. Okay, so Pattern. Pattern is the prisoner assessment tool targeting estimated risks and needs. So this is our risk assessment instrument. Sorry. So an inmate's risk is, there are a number of factors that we look at, and an inmate's risk is classified as minimum risk to recidivate, low, medium, or high. And one thing I want to point out, and this is a source of confusion that I've encountered for a lot of people, an inmate's risk level is different from his or her custody level. An inmate's custody level is something that the BOP has used for years and years and years and years. And it's basically an internal classification, and it's designed to help BOP house the inmate in a facility that's appropriate for his or her security needs. So you could have, let's say, a low risk inmate in a medium security facility, or you could have a medium security inmate with a minimum risk of recidivism. An inmate's custody level has no bearing with respect to the FSA. Like I said, it's BOP's internal classification system. We have a program statement that explains how we generate an inmate's custody level. It has nothing to do with an inmate's risk level under the FSA. But I'd like to clarify that because I have encountered quite a few circumstances where people are confused between the two. In particular, as you'll see as we get further down the line, when it comes to whether or not an inmate may be eligible to apply his or her FSA credits. We are currently on pattern version 1.3. So how do we determine an inmate's pattern score? So an inmate is assigned point values based on a variety of characteristics: age, history of violence, history and severity of incident reports, sex offender status for male inmates only, criminal history points, history of escape, their level of education, their work history, any substance abuse or drug program history, and programming history. And I can give you a link at the end of this. The BOP on our public website, it has the actual pattern scoring system on the website, and it's very easy to follow. You can look at it and see how we assign the points, what the breakdowns are for, if an inmate is low, it's this range of points. If an inmate is minimum, it's this range of points. So I can give you those websites if you're curious to see kind of in further detail. Pattern scores are reassessed at least twice a year. If an inmate is closer to his or her release date, they're actually assessed more frequently than that. So right now we are on, like I said, pattern 1.3, but in our annual report as of January 2022, using pattern 1.2 revised, there were 14% of BOP inmates were assessed as a minimum risk of recidivism, 30% low risk, 20% medium risk, and 36% high risk. Now the needs assessment, which is the SPARC 13. So eligible inmates get credit, FSA, First Step Act time credit for completing programming relating to his or her assigned needs. And we've identified the following 13 needs areas. And these areas specifically correlate to an inmate's risk of recidivism. The need areas are anger, hostility, finance poverty. So for example, does the inmate know how to manage finances? Has the inmate ever had a checking account? Do they, how familiar are they even with balancing kind of a monthly spreadsheet? Antisocial peers. So do they, even if they aren't necessarily diagnosed with antisocial personality disorder, do they have kind of what's their social interaction, their medical history, their mental health history, recreation, leisure, fitness. So kind of that can go towards a lot of things. That can go towards their health, that can go towards their coping skills, substance abuse history and substance abuse treatment, a work need. So does an inmate have a legitimate work history? Do they have any marketable skills? Can we get them marketable skills if they don't have any? A history of dyslexia, trauma. And this trauma is actually a big one where we have a lot of veterans in BOP custody. And one of the programs that's come in is through the VA. We have some programs in connection with the VA that specifically address PTSD and things like that, that former military members have faced that's unique to them. And I think those programs are particularly important, just in my personal opinion. Family parenting, we obviously a big part of risk recidivism is getting an inmate to maintain family ties. If the inmate hasn't had a connection with their family in years, can we get them to reestablish a connection? If the inmate has children, can we give them parenting courses to help him or her become a better parent on the outside, become more involved in his or her children's lives. Education and cognitions. How do they view criminal thinking? You know, do they make excuses for their behavior? Do they blame others? Do they blame outside circumstances? Do they take some sort of a look at their role in things and how they can change it going forward? So those are some of the need areas that we identify. And how are needs identified? So needs are identified through interviews interviews by the education department, the health services department, psychology and drug treatment teams, and by the inmates unit team. They're also assessed using an inmate's pre-sentence report. We also use verified testing instruments such as the brief anger aggression questionnaire, the Woodcock-Johnson 4, which I believe is, don't quote me on this, but I think that's dyslexia, I'm not positive. The adverse childhood experiences scale, all of those are, some of those I believe are administered by staff and some are self-administered by the inmate. They're available on the TrueLinks inmate computer system. So when an inmate comes into BOP custody during their admission and orientation and their first meeting with unit team, they'll be notified that these assessments are available on TrueLinks and they should take them at their earliest opportunity. And then once an inmate's needs are assessed, unit team will look at the inmate's needs and recommend commensurate programming. So for example, if an inmate has a substance abuse problem or substance abuse need, unit team will probably recommend drug education, non-residential drug treatment, residential drug treatment. If an inmate has an anger need, they may recommend an anger management class. If an inmate has a finance need, they'll recommend a Money Smart class. So at each inmate's unit, at each inmate's program review is done at least every 6 months. And at each inmate's program review, unit team will again look at the inmate's needs, look at the inmate's programming, recommend new programs. And as I said, an inmate's risk and needs are assessed at least on a semi-annual basis. They're assessed at least every 6 months, and on a more frequent basis if the inmate is closer to release. So what programming satisfies an inmate's needs? So not every program or activity qualifies as evidence-based recidivism reduction programming or a productive activity. The program needs to be it needs to be evidence-based. So there has to be some verified correlation or empirical research showing that this particular program has an impact on recidivism. But the definition has expanded quite a bit, I think, since the origin of the FSA, if you will. I think originally the definition that people were using was a lot stricter. Now, some programs that maybe, like I'm thinking of some faith-based programs and things like that, that may not have, that may not have actually done kind of the scientific studies to back it up and say, yes, we did a verified study with a control group and a non-control group, and this is what we found. I mean, if the powers that be look at a program and say, yes, this will help recidivism, and there's some evidence that it will help reduce an inmate's risk of recidivism, then it will be considered an evidence-based or productive activity for purposes of the FSA. And if there is an organization that offers a program that hasn't yet been approved and the organization wants to seek that approval, there's information on the BOP's website where the program, basically the organization has to provide a bunch of information about the program, about what the program does, about its goals, about how it impacts recidivism, and the powers that be will review it and will determine whether or not it can qualify as a EBRR or productive activity under the FSA. So here's a big one, earned time credits. So there have been a number of iterations on the way that BOP is calculating and applying earned time credits. Like I said, I'm going to give you the most accurate information that I have right now. I'm pretty certain that we're close to final, if you will. I think that, yeah, I'll reserve my comments. Earned time credits. Okay. So a big part of the FSA, inmates earn time credits for completing programs that relate to their assessed needs. In addition to earned time credits, inmates can receive other incentives. They can receive expanded phone and visiting privileges. That hasn't really been an issue because of COVID. When COVID hit, BOP removed the, essentially we removed the monthly allotment of minutes that an inmate has on their phones and visiting. Essentially, inmates could have unlimited phone calls and visiting. Obviously, that was a little trickier during COVID, and it depended on the institution and where the institution was with respect to its transmission rate and things like that. But the reason I bring it up is because the kind of additional incentives hasn't really been an issue of litigation or anything yet. But for inmates who, for example, may not be eligible to apply their FSA credits toward early release to supervision or pre-release custody yet, and we'll go into that. But those inmates may still be able to use their FSA credits towards increased phone time or increased visits or things like that. So the big thing, earned time credits can be applied towards pre-release custody or early transfer to supervised release for low and minimum risk inmates. Okay, so BOP implemented its final rules at 28 CFR 523.40 to 44. And this is the basic gist. An eligible inmate who successfully participates in evidence-based recidivism reduction programs or productive activities that are recommended based on the inmate's risk and needs assessment may earn FSA time credits to be applied towards pre-release custody or early transfer to supervised release. So, eligibility to earn FSA time credits. Okay. State offenders, per the language of the FSA, or I'm sorry, per the language of the regs. It's not actually in the FSA that state offenders cannot earn time credits. What the FSA does say is that an inmate has to be convicted of an offense under the US code. So for us, so where this comes up is you may have an inmate who's serving a federal and a state offense. Let's say feds had primary custody, the state sentences him as well on a writ, inmate comes back to fed custody, and so therefore they're serving a federal and a state sentence. In those circumstances, BOP's position, and there's some language in the actual FSA and the comments to the FSA that support our position. Our position is if an inmate is serving a concurrent state offense, a concurrent state sentence, that inmate is not eligible for FSA time credits. And basically the idea is we don't want to interfere with the administration of a state sentence. So there's been, to my knowledge, a little bit of litigation about that, because if the federal offense is FSA eligible, the argument is, well, I should get my FSA credits and then be transferred to the state earlier than I otherwise would. We'll kind of see how that shakes out, but currently BOP's position is if an inmate is serving a federal and concurrent state sentence, the inmate is ineligible to apply, or I'm sorry, the inmate is ineligible to earn FSA credits. DC code offenders right now are also ineligible. That's because the FSA itself says that an inmate must be convicted of a crime under the US code, but there's been some discussion, and there's something in the FSA that at the moment I'm forgetting, and I apologize, that contemplates that DC code offenders may in the future be able to earn FSA credits. What the BOP essentially is waiting for is when Congress implemented the FSA, they listed a number of offenses that made an inmate FSA ineligible. So what BOP is waiting for DC to do is basically do the same thing. So rather than give every DC inmate in BOP custody FSA credits, presumably DC would want to say, okay, an inmate serving a sentence for a conviction of, for example, murder, certain sex offenses, certain drug crimes, those inmates should be FSA ineligible as they are if they were serving a commensurate federal offense. So until DC does that, BOP's position is that DC offenders are ineligible for FSA credits. And like I said, that may change in the future, but that's our position as of now. Final orders of deportation. This is a fun one. So at the very beginning of BOP's implementation of the FSA, inmates who had a detainer from ICE, but not a final order of deportation, BOP's position was that those inmates were ineligible to earn FSA time credits. BOP has since walked that back, and now inmates who have an ICE detainer, but not a final order of deportation, are eligible to earn FSA credits, and they can have 365 of those FSA credits applied towards early release to supervision, as long as they have a term of supervision. Right now, BOP's position is that any additional credits over 365 cannot be applied towards pre-release custody. There is, to my knowledge, some discussion about that, but I don't know. And I know I personally have some litigation in other districts about that point. So we'll see kind of as things evolve, but that's BOP's position at the moment. And one thing I'd like to highlight that is tough when it comes to applying FSA credits towards pre-release custody for inmates with detainers but not final orders is with respect to home confinement. A lot of these offenders don't have an address in the US. So the only pre-release alternative really is a halfway house, and some of the halfway houses, BOP contracts with halfway houses, and some of the halfway houses, for obvious reasons, they may balk at taking inmates with ICE detainers. And there's also the kind of reality that an inmate with an ICE detainer, if we put them in a halfway house, some of them may not necessarily stay there. So there's practical considerations to BOP's position. But like I said, we're kind of, I know there are discussions well above my head about all of that. But we are applying the 365 credits at least towards early release to supervision for inmates who have detainers, but not final orders. And I'm sorry, I should have started that whole tangent by saying that the FSA specifically excludes inmates who have final orders of deportation from earning FSA time credits. I think that was hopefully implicit in my tangent, but if it wasn't, inmates who are the subject of a final order of deportation are explicitly precluded from earning FSA credits. And an inmate cannot earn FSA time credits if he or she is serving a current term of imprisonment for an offense listed in 18 USC 3632 D4D. And we'll go into all of these in a little bit of detail. I have specific slides on drug crimes and the catch-all provision, but I want to talk a second about conspiracy. So unless a conspiracy offense is actually listed as one of the FSA disqualifying offenses, BOP will not make an inmate ineligible on a conspiracy offense. So, for example, RICO is a good example. The FSA makes a conviction for murder. So murder is a disqualifying FSA offense. If an inmate is convicted of RICO, but you read their PSR and that RICO involves a murder, that inmate is FSA eligible because RICO is not a specifically enumerated disqualifying offense. Now, sometimes you can get RICO offenses under the catch-all provision, but sometimes you can't. And I'll go into that because that can present some interesting inequities, in my opinion. I had, for example, 2 inmates at the same institution. They were co-defendants, and their PSRs were almost identical. They participated in the same course of conduct, and one of those inmates was eligible because his offense was RICO. The other inmate was ineligible because his offense was also RICO, but he had a disqualifying prior conviction. So I'll get into that when I talk about the catch-all provision. But just kind of keep in mind when you're charging an offender, when you're working out pleas, conspiracy, unless it's specifically enumerated as a disqualifying offense in the FSA, BOP is not going to consider that disqualifying. One conspiracy off the top of my head that I can think of that the FSA does call out is conspiracy to smuggle certain aliens into the United States. There's one of the offenses listed in 3632 D4D specifically says that conspiracy makes an inmate ineligible. But normally a conspiracy, unless it's, like I said, unless it's actually listed in 3632 D, it's not going to make an inmate ineligible. One of the other things I want to talk about before I flip slides is supervised release violations. So if an inmate, so right now, the way the BOP is looking at things, and again, this potentially may be subject to change, but if an inmate comes back on a supervised release violation, if there is no new offense, BOP will look at the original offense for purposes of FSA ineligibility. So for example, let's say an inmate has a 924C conviction, and 924C is one of the offenses listed in 3632 D4D. So if you're convicted of 924C, you are not eligible to earn FSA credits. So let's say an inmate has a 924C offense. He or she serves their term of imprisonment. They're released on supervised release. They get picked up for failing a drug test, and they come back to BOP custody. That inmate would still be ineligible to earn FSA credits because their original offense, 924C, is a disqualifying FSA offense. Now, let's flip it a little bit. Let's say that inmate comes back on a supervised release violation, but the inmate also incurred new charges. And let's say the new charges are for an FSA eligible offense. BOP's position now is that if the new offense is FSA eligible, the inmate can earn FSA credits. And that is a fairly recent change, because BOP used to say that if the original offense was FSA ineligible, then it didn't matter whether the new offense was eligible. The inmate would still be ineligible on that aggregated term. So it can get a little tricky when it comes to supervised release violations, but that's the position that we're taking right now. One other thing I wanted to point out before I flip the slide to drug crimes that I didn't have on this slide is sex offenses. So when you're charging offenders, when you're working out pleas, it's really interesting to me, as I've been doing this over the past 2+ years, 4 years, I guess now, in determining eligibility, what offenses Congress decided to make FSA eligible and what offenses they didn't. So a lot of your sex offenses under 2241, I believe, there's a certain category of sex offenses under Chapter 109A that are FSA ineligible. But there's a bunch of sex offenses under Chapter 117, which is 2421 through like 2429, I think, something like that, that are FSA eligible. So, for example, an inmate, if an offender, let's say an offender has been caught with possession of child pornography, that offender would be FSA ineligible. But let's say an offender went online, solicited an underage person and decided to meet them at a diner. And when they show up to the diner, it's actually an undercover agent. So the offender is charged with solicitation. That offender is FSA eligible. And it's just really interesting. The reason I point that out is because it's interesting to me that Congress, kind of, but for that agent being an undercover agent, that person would have presumably met a child and done something potentially really bad. But yet the person who has child pornography on their computer is FSA ineligible. And not to say that one offense is any worse or better than any other. It's just kind of my personal observation that I wanted to highlight a little, because I just think it's really important as you're thinking about how to charge someone, what to charge them with, defense counsel, what to plead to, what to negotiate. I think it's really important to keep in mind what's FSA eligible and ineligible and how it's going to impact your client or the offender. Okay, so flipping slides to drug crimes and eligibility with respect to drug crimes. So as I was saying, conspiracies, unless it's actually specified in the FSA, conspiracies do not make an inmate ineligible. So an inmate who's convicted under Section 846 is not disqualified. If an inmate has a separate count for an 841 violation, and that 841 violation is disqualifying, the inmate will be ineligible. But I'm sorry, it gets confusing. I'm sorry. I guess what I'm saying basically is, in the JNC, kind of say what you mean and mean what you say. And what I mean by that is, if it's an 846 violation, make it clear that it's an 846 violation. If it's an 841 violation and the inmate actually possessed, distributed, dispensed, did the illegal thing with the drugs, make that clear so that we know, because sometimes I've seen JNCs where it's not necessarily clear whether the 841 is a separate count or if the 841 is kind of just the guideline, if you will, that the offender was sentenced under. So I always like to call that out. The way that the FSA works with drug crimes is only certain drugs and certain amounts make an inmate ineligible. So for example, if an inmate was held responsible for having over 40 grams of fentanyl, he or she is automatically FSA ineligible. if an inmate had over a certain amount of heroin and he or she was found under the sentencing guidelines to be an organizer, leader, manager of the enterprise, he or she is FSA ineligible. So the reason I bring that up is because it's really important when BOP is reviewing these things to make sure that we can clearly know what is the drug amount and what's the role that the person had in the offense. You know, was there any sort of a sentencing enhancement with respect to their role, with respect to whether or not the person was responsible for a serious bodily injury. One of the things I've seen with the PSR, which can be frustrating a little bit, is when all the drugs are lumped together to give you one big drug amount. And that's unfortunately not helpful if the inmate had, let's say, fentanyl, cocaine, and heroin. Because like I said, for fentanyl, all you need is 40 or more grams. It doesn't matter the inmate's role. It doesn't matter whether serious injury occurred. All you need is 40 plus grams of fentanyl. But if I'm looking at a PSR that says the inmate was responsible for 500 grams of fentanyl, cocaine, and heroin, well, that doesn't tell me how much fentanyl the inmate was responsible for. And unless the PSR says that somewhere else, I don't know. And especially if the JNC doesn't specifically call out subsection 841 B1A, B1A6 or B1B6, which is the provision that involves 40 plus grams of fentanyl, I won't know. I don't know how much fentanyl the inmate had. So that may be a little bit confusing, but basically the bottom line is kind of if you can make the JNC and the PSRs as clear as possible, it does help us out. And along those lines, it's helpful if the JNC lists the subsection for drug offenses. So it's very, very often that I'll see a JNC that says the inmate was found guilty of 21 USC 841 B1B, which is great. But again, for the FSA, it matters how much the inmate had. It matters what type of drug the inmate had. So, and some BOP attorneys even take the position that they take a very literal position where the FSA specifically says, when you look at 3632 D4D, that statute includes the subsection. So some BOP attorneys say if a JNC doesn't include the subsection, even if the PSR supports making them ineligible, that inmate is eligible because the JNC doesn't have the subsection. Now, I personally don't take that position. I won a case in Massachusetts that supports kind of my reading of it, which the inmate was convicted of 841 B1B, and the PSR and his sentencing documents made it clear that he had 40 plus grams of fentanyl, but the JNC just said 841 B1B. But the judge in Massachusetts agreed and said, no, like BOP is reasonable in saying that that his offense of conviction is B1B6. But not all districts might have necessarily seen it that way. So my point basically is if the inmate is being convicted under a certain subsection with respect to a drug offense, just make it, put that in the JNC and it makes it easier for everybody. Same thing, any role enhancement, mandatory minimum, just please make sure those are in the PSR and the statement of reasons. Death, serious bodily injury. So this one is a little tricky and there's some litigation around it. So there was a case out of the Eastern District of New York that held that even though the inmate received an increase in the guideline range because a death or serious bodily injury occurred as a result of the drugs, that inmate wasn't sentenced to the mandatory minimum because the judge found a reason to deviate. And in the EDNY case, it was found that that inmate should be FSA eligible specifically because she wasn't sentenced to the mandatory minimum. So that can be a little, I'm sorry if that wasn't completely clear and it's a little confusing, but I guess my point on it is if an inmate, if the goal is to have an inmate be FSA ineligible because a death or serious bodily injury occurred as a result of the use of the drugs that he or she sold, keep the mandatory minimum in mind, because it's looking like some jurisdictions, if the inmate was not sentenced to the mandatory minimum, might deem the inmate FSA eligible, even if a serious death or bodily injury occurred. So that's kind of an evolving issue, and we'll kind of see how all that shakes out. But another thing I wanted to point out is that 924G is not disqualifying. So as I mentioned, the reason I put this under drug crimes is you'll often see a drug offense and a 924C together. But I've also seen a drug offense and a 924G together, and 924G is not disqualifying. And I had a conversation with a few BOP attorneys because we were having kind of an internal debate in that some people read it that 924G encompasses all the elements of 924C and then some, but our ultimate landing was that 3624D4D says what it says, and it has offenses that Congress specifically said are FSA ineligible. 924C, in Congress's opinion, specifically makes an inmate ineligible, and 924G does not. So if an inmate is convicted under 924G, he or she will be FSA eligible, at least based on the 924 offense. Now the catch-all provision. So this was kind of, I think, Congress's way maybe of saying like, hey, anything we forgot, anything we forgot, this should cover it. So the catch-all uses a definition that we're all familiar with. The inmate must have a current federal conviction for an offense punishable by 10+ years that has as an element the use, attempted use, or threatened use of physical force against the person of another, or that by its nature involves a substantial risk that physical force against the person of another may be used in the course of committing the offense. So this is where I was saying with some of your RICO offenses, based on the details in an inmate's PSR, oftentimes a RICO offense will fit this definition, at least, based on the offense conduct that we know about. But the catch kind of to this is the second slide, which is that to be ineligible under the catch-all, the inmate must also have a disqualifying prior conviction, which means that in addition to having a current federal offense that has as an element the use of force, yada, yada, the inmate must also have served a year plus on either a prior state or federal conviction for murder, voluntary manslaughter, assault with intent to commit murder, aggravated sexual abuse, abuse of sexual contact, carjacking, terrorism, or arson. And the FSA says that these prior offenses, the prior offense needs to be analogous to the elements in the like federal offense. So for example, if an inmate, let's say an inmate has a prior conviction for murder in the state, we need to look at the elements of, let's say they have a prior conviction for murder in Rhode Island, right? So I would need to go to the statute in Rhode Island and say, okay, what are the elements for murder in Rhode Island? What are the elements for murder under the US code? And if they are, and they essentially need to be pretty exact to qualify as as a disqualifying prior offense. So that comes into play sometimes, especially when you get into maybe like voluntary manslaughter or assault with intent to commit murder, things like that, because those types of offenses can be very, they can vary a lot. The definitions and elements can vary a lot state to state. So it can get a little tricky sometimes. Oh, and going back to, so I want to go back to my example a little bit with the two RICO defendants. So as I mentioned, I had two defendants, co-defendants actually, who, you know, their PSR was basically the same. One of the inmates had no criminal history. The other inmate had a bit of a criminal history, and one of his prior crimes met one of these offenses. So the inmate who had no criminal history, he was FSA eligible, and the inmate who had a prior federal conviction, he was not eligible for FSA time credits. And I suppose you could say that the inmate with more criminal history, that's the reason he was ineligible, and it wasn't quite inequitable. But to me, if you looked at their PSR and the details of their PSR, it was they were involved in some pretty astonishing conduct, I guess. So the idea that they would be treated differently, you know, whether both FSA eligible or both FSA ineligible, it just kind of struck me a little that the two would be treated differently for FSA purposes. But I didn't write the statute, so. And again, I apologize if any of my kind of offhand commentary, that's not representative of the Bureau. Like I said, I've been reviewing these for 4 years, and sometimes you see some things that just stick in your head. So I just like to point those out kind of for, I think they're good talking points or thinking points. But I hope I don't offend anybody by maybe my commentary that may or may not be supported by the BOP. All right, so what do earned time credits do? So eligible inmates, people who have earned FSA time credits, may have them applied towards pre-release. So pre-release is halfway house, which is an RRC, or home confinement placement, or they may be applied towards early transfer to supervised release. Inmates will earn FSA time credits towards early transfer to supervision until they have 365 days. After 365 days, any additional credit is applied towards pre-release custody placement. And the 365-day time limit comes straight from the FSA. That's right from 3624G3. And that allows BOP to apply FSA time credits towards early transfer to supervision for up to 12 months. We can't apply any FSA credits beyond 12 months towards early transfer to supervised release. So eligibility to apply. Now this is different than eligibility to earn. So an inmate may be earning time credits, but he or she may not be able to apply them yet. So to be eligible to apply FSA time credits, the inmate must have earned credits in an amount that is equal to the remainder of the prisoner's imposed term of imprisonment. So this is a big one right now because we have some inmates with projected release dates in 2027, 2028, 2029, and they're all saying, you know, hey, I want my FSA time credits applied. And if you do the calculation, even if they started earning credits in December of 2018, there's no mathematical way yet that they will have earned time credits in an amount equal to the remainder of their imposed term of imprisonment. And it's interesting because BOP attorneys kind of had this discussion too, back and forth a bit with respect to imposed term of imprisonment. Some BOP attorneys were saying that imposed term of imprisonment should refer to the inmate's full-term release date. So when we're looking at the amount that an inmate has remaining, we should look at an inmate's release date as if they had no good conduct time under 3624B. Other people were saying, no, 3624B is essentially statutorily guaranteed unless an inmate actively loses it. So where we came down, where BOP came down, we use an inmate's projected release date with good conduct time credits, accounting for good conduct time credits. So, and I have a slide at the end of this that goes through a sentence computation, so you can see basically what I mean. But in terms of looking at how much time an inmate has left on their sentence, we'll use their projected release date, accounting for 3624B good conduct time. Oh, and I put 3621B. I'm sorry, that's a typo. It's 3624B. That's the 54 days of good conduct time. So for transfer, so in addition to having credits in an amount equal to the remainder of their term of imprisonment, an inmate to be transferred to pre-release custody must have been considered a lower minimum risk for their last 2 risk assessments, or if the inmate is high or medium risk, then he or she must be approved for such a transfer by the warden. And there is a procedure in BOP's program statement that explains that the inmate is supposed to make such a request during his or her unit team during their regularly scheduled program review. And the request goes up to the warden, and the warden considers a number of factors such as, the inmate's disciplinary history, the inmate's programming history, things like that. And then if appropriate, the warden will forward a recommendation, the warden will make a decision, but the warden will make that decision in consultation with the regional director. And to go back to the low minimum risk assessment during the last 2 risk assessments, what BOP had been doing is we had been kind of considering an inmate's first low or minimum risk assessment as their baseline and saying, okay, you need 2 more after that to be your 2 consecutive risk assessments, your 2 last risk assessments. Now we are just looking at literally the last 2 risk assessments. So I've kind of been calling it a baseline plus 2. Now it really is 2. It's just a straight 2, if that makes sense. And for early transfer to supervised release, the inmate must be a lower minimum risk. There is no waiver if the inmate is a higher medium risk. There's no ability for the warden to approve. That's straight from the statute. The inmate has to be a lower minimum risk in order to have his or her credits applied towards early transfer to supervision. The inmate must also be successfully participating to have FSA credits applied. And this is where there has been some discussion kind of about how we're actually implementing the FSA. So inmates really are, the way to think about it is they're getting credit unless they're not. When an inmate gets to a BOP institution, when they get to their BOP designated institution, they'll have their risk and needs assessment, and they'll have their and they'll have their meeting with unit team where unit team recommends programs. As long as the inmate is willing to participate in those programs, he or she will be earning credit, even if they aren't actively participating in those programs yet, as long as they aren't refusing those programs. So for example, an inmate may be recommended for, let's say, the Money Smart program, but the Money Smart program may have a waiting list. Well, we aren't going to penalize the inmate for being on the waiting list. If the inmate is working, the inmate is doing everything that they're supposed to while being on the waiting list, then he or she will be earning FSA credits during that time. So really, it essentially is, as long as the inmate is willing to participate in the recommended programs, he or she will be earning credit. And the reason, part of the other reason BOP is doing it this way is, you know, we kind of saw during COVID, we weren't able to offer programming in the traditional ways a lot of times. And so there were interruptions in programming and things like that. And legitimately, inmates shouldn't be penalized for circumstances outside of their control. So temporary operational or programming interruptions, we aren't going to say to an inmate, no, you can't earn credit during that time, as long as the inmate was willing to program. So an inmate is considered not successfully participating if the inmate is in SHU for disciplinary reasons. Now, one highlight note that I say for disciplinary reasons, an inmate in SHU can still be earning FSA credits as long as he or she is not in there serving disciplinary time imposed by the DHO. And that's because inmates in SHU can engage in some programming. Education makes rounds, psychology makes rounds in SHU, and psychology in particular, a lot of times, especially if an inmate may be in SHU, let's say pending a transfer, let's say the inmate had there, for example, let's say there has been a verified risk to the inmate on the compound. So we're transferring the inmate out, but the inmate may be in SHU for a couple weeks until that transfer actually goes through. And so the inmate, we want to give the inmate things to do during those 2 weeks. So psychology and education in particular will give the inmate kind of self-guided programs and things like that. And so the inmate should get FSA credit during that time. So unless they're in SHU for disciplinary reasons, they should be getting FSA credit. An inmate will not get credit if they are outside the institution. Again, for obvious reasons, if they're outside the institution, they aren't participating in kind of BOP authorized programs. So if an inmate is on furlough, if an inmate is and this goes along with temporary transfer to another federal or non-federal agency. If the inmate is out with a marshal's on writ, if the inmate that comes into play a lot of times. If an inmate's out on writ, they are generally not housed in a BOP institution. Usually they're housed, you know, the marshals have contracts with various state facilities and things like that. So the inmate isn't going to be engaging in EBRR or PA. And the other way an inmate is not successfully participating is if he or she actively tells unit team, you know, hey, I know you recommended that program, but I have no interest, I'm not doing it. If an inmate is what we consider opting out, then he or she at that point will not only not be able to apply credit, but he or she will also not be earning credit at that point. So calculating credits. So BOP developed an automated system which calculates credits. The inmate begins earning credit either on the FSA enactment date, which is December 2018, or if the inmate came into BOP custody after December 2018, the inmate will start earning credit on the day he or she arrives at their designated institution. And that's actually in the BOP's regulations. So the FSA said that an inmate could not begin earning credits before enactment of the FSA or before his or her sentence commences. So pretrial inmates, per the language of the FSA, cannot earn credit. Even if they're programming, they cannot earn FSA credit. BOP said, we'll start giving you credit when you get to your designated institution. And sometimes it does take a month or two after an inmate is sentenced before an inmate gets to their designated institution. But the reason for BOP's regulation is because most pretrial inmates aren't housed in BOP institutions. So again, We don't know if they even are programming, or if they are programming, if those programs meet FSA standards, if they're, evidence-based recidivism reduction. Oftentimes they're state facilities that BOP has no way to really verify information and what the inmate is doing over there. So for that reason, inmates begin, and the other thing is we also, an inmate is supposed to be taking programs commensurate with their needs. Well, if an inmate hasn't been in BOP custody yet, we don't know what his or her needs are. So even when an inmate gets into a BOP facility, it's true that he or she earns credit for programs that may not be related to their needs, but they are at the same time waiting to complete programs that are commensurate with their needs. So that's kind of the reason why BOP doesn't begin credits as of the day of sentencing. We begin credits when the inmate arrives at his or her BOP designated institution. The automated system updates each inmate's calculation on a monthly basis. And as I kind of mentioned, inmates receive credit for essentially all programming, not just programming associated with his or her needs. So if an inmate, let's say an inmate again, unit team recommended Money Smart, but the inmate's on the waiting list for Money Smart, but in the meantime, he or she is taking, a health and fitness class. That's great. Like we aren't going to penalize an inmate or not give him or her credit for doing something productive with their time. Inmates receive 10 days of time credits for every 30 days of successful participation. And after 2 consecutive lower minimum risk assessments, the inmate starts to receive 15 days for every 30 days of successful participation. And this is another area where I had mentioned before, BOP had been, they had been wanting kind of a baseline lower minimum and then 2 consecutive lower minimum assessments. We have changed that. So now, as soon as an inmate has his or her second consecutive low minimum assessment, he or she will start earning 15 credits. An inmate may lose FTCs for a violation of the requirements or rules of an EBRR program or PA. I haven't really seen this happen yet, to be honest. This, as I understand it, this would have to be, an inmate is actively in a program and starts to cause some sort of a disturbance or something like that. And this would be separate from any sort of an incident report that the inmate gets. So, like I said, I haven't really seen it in play. My guess is that most of the time BOP would probably just issue the incident report and have it go through the disciplinary process. Then necessarily have an inmate lose FTCs, but I'm not sure. I just haven't really seen it much yet, so we'll see how that shakes out. I want to bring up this slide because there's been some confusion I've seen, and maybe it's just terminology, but there are other ways an inmate can earn time off their sentence beyond the FSA, but they're all very different and distinct statutes. So I want to make sure that everybody knows that they're separate and everybody is kind of clear on what the different statutes are. So as I mentioned before, an inmate is eligible, or I'm sorry, an inmate is essentially given 54 days of good conduct time per year of their imposed term under 3624B. And that time is really the inmates to lose. So for example, if an inmate has a 10-year sentence, they're given 554 days off the bat, really. And if they incur discipline, that time can be taken away, but that time is really statutorily guaranteed unless the inmate actively loses it. 18 USC 3621E is residential drug abuse treatment early incentive. So that's the RDAP program. So that's, I don't know how familiar everybody is with RDAP. Probably most people know of it. But RDAP is the BOP's residential drug treatment program where the inmate spends a certain amount of time in a specific housing unit in a BOP facility that's designed kind of like a therapeutic treatment community. And then the inmate has follow-up care after going back into general population, and then the inmate will go into community custody towards the end of his or her sentence and participate in drug treatment while at a halfway house or on home confinement as well. And assuming that the inmate completes all three components successfully, the inmate is eligible to receive up to a year off his or her sentence. And I'm going to show you in a minute kind of the interaction between an RDAP early release and FSA credits, how they work together. The other kind of, this isn't time credit as in time off an inmate's sentence, but it's another way that inmates can be placed in pre-release custody. So the Second Chance Act says that BOP shall, to the extent practicable, ensure that a prisoner serving a term of imprisonment spends a portion of the final months of that term not to exceed 12 months in pre-release custody. The FSA specifically removed the 12-month requirement if the inmate has sufficient FSA credits. So for example, if an inmate has, math is not my strong point, but let's say the inmate has the equivalent of 3 years of FSA credit. The first year of FSA credit will go towards the inmate's term of early transfer to supervision. And the other 2 years, once the inmate hits FSA credits in an amount equal to their term, those 2 years can be applied towards pre-release custody. So it's not the case anymore under the FSA where we are limited to putting an inmate in pre-release custody for a year. We can put them in pre-release custody longer if they have sufficient FSA credits. And one thing that I didn't put on these slides is the CARES Act. The CARES Act essentially took away the time limit under 3624C as well. Because of the pandemic, the CARES Act said that BOP could put inmates on pre-release placement longer than 12 months. The CARES Act, as everybody has probably heard, is going away at the end of the month. So that's really no longer an issue. But the FSA is a way that inmates may spend longer than 1 year in pre-release placement. So I wanted to go through an example kind of just to show you how an RDAP early release and the FSA kind of work together. So let's see. So I'll go over to this one. So this inmate has, whoops, sorry. All right. This inmate was sentenced to a 210-month sentence, right? So if this inmate served his full sentence, so that means no good conduct time, no 54 days, no RDAP early incentive, nothing. If this inmate served his full sentence, he would release on June 3rd, 2030. That's right there. Whoops, right there. I didn't highlight that, but June 3rd, 2030. We really never, that date is on there, but for BOP purposes, I've never really used it because, like I said, all inmates get some amount of good conduct time credit. Even if they incur a lot of discipline and lose quite a bit, they still get something. So an inmate's statutory release date, statutory projected release date, this is an inmate's release date with 3624B good conduct time, the 54 days per year. So this inmate's release date with good conduct time is November 2nd, 2027. Now, this inmate participated in RDAP. He participated in the institution part of RDAP. So he lived in the therapeutic housing unit in a BOP institution. He completed that on July 21st, 2021. he will go to a halfway house or on home confinement closer to his projected release date to complete the third component of RDAP. But assuming that he does complete that third component, he's eligible for a year off his sentence. So his sentence will, or his release date will go from November 2nd, 2027 to November 2nd, 2026. Now, he also earned 365 FSA credits. So his release date goes from November 2nd, 2026 to November 2nd, 2025. Now he is eligible for RRC home confinement placement under the Second Chance Act a year before his projected release date, which would be November 2nd, 2024. And you can see all of this on his sentence comp. So this is his projected release date with good conduct time. This is his projected release date, assuming he completes RDAP successfully. And then this is his release date after the 365 days of FSA credits. And so you're probably asking, well, why can't he go to pre-release custody sooner than November 2nd, 2024? And the answer is because this particular inmate right now has 735 FSA credits. However, he has 1,651 days remaining on his term of imprisonment right now. There's 1,651 days between today and November 2nd, 2027, which was his good conduct time date. Now it may be, and I didn't do the math because I'm terrible at math, but it may be that he reaches enough FSA credits that he has an amount equal to the remainder of his term of imprisonment before November 2nd, 2024, in which case we could put him in an RRC or on home confinement before November 2nd of 2024. But I just didn't do that math because you probably don't want me to. One thing that I suggested that I know other people have suggested as well, to make it easier, and I hope powers that be are contemplating this, is to add a line on a sentence comp, so that, or kind of a line that updates so that we know how many FSA credits an inmate currently has and how many days are left on his or her sentence. I don't know if BOP is going to add that. I don't know how easy it is to add things to the sentence monitoring computation data, but it would be helpful, I think. And this is this particular inmate's time credit assessment sheet from the automated system. So you can see that this inmate, so he was in custody when the FSA was enacted. So he started earning credits on the day that the FSA was enacted, 12/21/2018. And he had his first risk assessment on January 18th, 2019. He was assessed as a minimum risk. He had his second risk assessment on July 17th, 2019. He was assessed as a minimum risk. So, So as of July 17th, 2019, which was his second consecutive minimum risk assessment, he started earning 15 credits for every 30 days. And you can kind of see this as an example where he didn't earn credits for 6 of the days because he was transferring in between institutions. He also didn't earn credit for 1 day because he was out on a furlough. But otherwise, again, he was earning 15 days after his second consecutive low or minimum risk assessment. And here you can see he's accumulated 365 days towards early transfer to supervision, which is the maximum that BOP can give him towards early transfer to supervision. And then he's accumulated the remainder, 370 credits towards pre-release custody placement. So that is kind of all I have at the moment. I left about a half hour for questions. I will try and answer them as best I can.
All right, great, because we do have some. All right, we have a question, and I think this goes back to the amount of credits that are given. What happens when you have an inmate who received a very short sentence, say like 12 years in a day or something like that? Um, and the gist of the question is, is the most, I'll read it to you. Does this mean that the most an inmate can get released early on these credits is 12 months? Is there a way for that inmate to come in and basically be ready to go out? Is there a cap on how much earlier than the end they can be released in that kind of a case?
Oh, so, okay, so you're saying an inmate who has a 12-month and a day sentence.
Yeah, that's just one
Yeah,
example. I think the question more generally is there a cap on the amount of time an inmate can get released earlier? You know, in the end, is there a maximum number of days they can get off their sentence? But also, how does this play out in a very short sentence?
okay. So the max that an inmate can get off their sentence is 365 days.
Okay.
An inmate will never be released unless, sorry, an inmate will never be released through the FSA any earlier than a year earlier than they otherwise would have.
Okay.
That said, the kind of cap, so to speak, is it's that the inmate must have earned time credits in an amount equal to the remainder of their imposed term of imprisonment. That's really kind of the cap. So if you think about an inmate who has a 12-month sentence, when that inmate comes in after the first 30 days, they'll get 10 credits, right? And they'll have 11 months left. I don't know how many days that is. I'm gonna do really bad math right here. Hold on, let me get my calculator. Can you guys see that? Can you see the calculator on my screen?
Mhm.
Okay, so I'm gonna do really bad math. So let's say 365 days. Let's say, so an inmate starts with, and I'm not accounting for good conduct time. His sentence is gonna be shorter. Well, actually I can, hold on. Please don't hold me to any of this math, but I will try. All right, so let's say an inmate has, 366 days, because to be eligible for good conduct time under 3624B, you have to be sentenced to a term over a year. So let's say the inmate has 12 months in a day, and he gets 54 days off right off the bat. So he's got 312 days left on his sentence. Now, after the first 30 days, he's earned 10 FSA credits, and he's also served about 30 days. So now he has 10 FSA credits and 282 days left on his sentence. After the second 30 days, he's earned 20 FSA credits, and he has 252 days left on his sentence. After the third month, he's earned 30 FSA credits, and he has 222 days left on his sentence. So I can kind of keep doing the math, but you'll see there will be a point at which his number of FSA credits will be equal to the remainder of his imposed term of imprisonment.
Mhm.
And at that point, he would be eligible to, well, this guy is, his credits are going to be applied towards early transfer to supervision, because the first 365 go towards early release. So they would be applied towards early release. But it, yeah, that's kind of basically the cap. The cap is this.
Okay. Is
That's,
there I assume that the automatic system that BOP has in place for calculating the amount of time left, it has some sort of algorithm by which it can predict what the amount of time off is going to be, taking all these different buckets of time into account?
so that is, to my understanding, what we're working on right
Okay.
now, because the FSA, because we only started awarding credits, the earliest we would award credits is December 21st, 2018.
Mhm.
It hasn't really become that big of an issue yet, but it will, as inmates start earning more and more credits, and as as we kind of push out on time, and inmates, especially with inmates who have longer sentences. So So my understanding is, yes, they are, they're looking at a way to essentially figure that out, and
Okay.
make sure that as an inmate approaches the point in time where he or she has time credits in an amount equal to, at that point, can, um, we can refer the inmate for pre-release custody placement.
Okay, let me go through a couple other questions. There was an inquiry whether you'll be willing to make the slides available after the presentation to people who want them.
Sure.
Okay, we can get them, excuse me, emailed out by the court. Another question, does the distribution of fentanyl under a certain amount make an inmate eligible for earned good time? I know you talked about a threshold where 40 grams or more, they're not eligible. So is the flip side of that, if it's under 40 milligrams or 40 grams, are they eligible?
So if an inmate has under 40 grams, he or she is ineligible if they were also found to be a leader, organizer, manager, if they have a sentencing enhanced, actually, I think I have the language right in front of me. If you give me a second. So if an inmate has less than 40 grams, that inmate will be ineligible if the sentencing court finds that the offender was an organizer, leader, manager, or supervisor of others in the offense as determined under the guidelines promulgated by the United States Sentencing Commission.
So, the bottom line here is that if you have Venn diagrams of people who cannot be eligible for a certain amount of fentanyl and people who can, there's some subsection of those where they will be eligible for time credit because
Right.
they won't have an enhanced role and they won't have possessed the amount of drugs over that statutory threshold.
Correct.
Okay.
Correct.
Let me see here. What happens if an inmate, well, let me back up. Does the BOP automatically calculate if an inmate's going to be eligible for one of the programs for early home confinement, or does an inmate have to apply for that? And if the inmate does have to apply, what happens if the inmate's rejected?
So you're talking about the terminally ill offender and
Yes,
the elderly
yeah, right.
offender. Generally, the inmate has to make a request with his or her unit team.
Mhm.
And then if the inmate is denied, they can appeal through the administrative remedy process.
Okay. All right, another question. If an inmate earns, this is the question wants to know if this is correct. If an inmate earns 3 years worth of credits and has 3 years remaining on his sentence, will the inmate get 1 year off the sentence entirely plus 2 years early release to home confinement?
The inmate will get a year off his or her sentence, yes, and 2 years in either home confinement or an RRC, or both.
Or a
Or a
combination?
combination of both, as long as that inmate, where is it? As long as that inmate has also been deemed to be a low or minimum risk.
Right.
Yeah, as long as the inmate is a low or minimum risk during the last 2 risk assessments.
Okay. Let's see here. Just by way of information, the Sentencing Commission has forwarded to Congress a group of proposed amendments to the sentencing guidelines, among which are proposed amendments to the definition of extraordinary and compelling circumstances. You are correct about that. I believe Congress has until November 1st to act to reject them. And if not, at that point, I believe they go into effect. I could be off on the date by which they go into effect, but that's approximately it. Let's see. I don't have any other more questions in the chat, and we have gone the length of time necessary to get 2 CLE credits under Rhode Island's Through the Looking Glass, 50 minutes equals an hour. So if anyone has any more questions,